Welcome as you arrive to this second seminar that BLACA has been able to hold online. It's a very great pleasure that you can join us here with a fantastic panel to talk about a very important and recently developed topic. I will make my substantive remarks in just a moment when everyone's had a chance to arrive. And I think Jeremy Bloom, the chairman, will give me the thumbs up when he feels that has happened.
We might as well start, Alison. Thank you.
Thanks. So again, I extend a formal welcome to everyone to this second online BLACA meeting. But this time we're lucky to be holding this meeting jointly with the blog IPKat. And on our distinguished panel of speakers is Professor Eleonora Rosati, now of Stockholm University, who is the leading light of IPKat. And she and her fellow panelists will discuss the Attorney General's opinion on communication to the public in the YouTube and Cyando joined cases. This is very recently released, only last week, this time last week, and even more recently released in the English language. So Eleonora's friends, her distinguished and incredibly widely qualified panel, give us a big boost from various jurisdictions and various backgrounds. So first of all, from the background of politics, we're delighted to welcome Julia Rader, former member of the European Parliament for the European Pirate Party, and she did a huge amount of work whilst a member of the European Parliament on copyright matters and clarifying some very important issues. She's now working for a project, a copyright control project with a German fundamental rights organization. We're also joined by Lauri Reichart of the IFPI, the International Federation of the Phonogram Industry, as was, and he joined IFPI with a distinguished legal practice background in Finland, but also experience as a director of the collecting society Gramex. Of course, Eleonora, as among her many accomplishments, is a qualified advocate in Italy. And in the chair, we have Jeremy Bloom of Bristow's, and he's qualified in New Zealand as well as England and Wales, and has appeared as a litigator in a number of high-profile cases about online infringements, including the L'Oreal and eBay trademark case. Now, we're very, very grateful to Jeremy for acting as chairman and Bristow's for hosting this online webinar as they host our offline meetings in other kinds of era. So I'll thank all the panelists warmly and hand over to Jeremy for some housekeeping tips and to introduce the topic. Thank you very much.
Thanks, Alison. So I'm delighted to be chair of today's session, and just a little bit of housekeeping. I won't be talking about fire exits or where the toilets are, but the session is going to be about 1 hour and a quarter, and would be delighted to have questions if there's time for those. If you do have a question, feel free to use the functionality on the portal, and then I will try to field those questions at the end of the session. Just a word of warning, it does come up with your name if you ask a question. So if you don't want to be known who's asked a question, don't ask a question, because we do want to attribute the questions to a named person. We are going to record this session. Well, we're trying to record it, subject to technical issues, which always arise. So hopefully we'll have this available for catch up later on. So do look out for that. We'll keep you posted if that is possible. And then finally, as Alison mentioned, this Advocate General opinion has just come out recently. So there hasn't been that much time to really digest it and analyze it. So today's session is about these initial views about the panel's thoughts on this. So, you know, it could be subject to change over the next few weeks or in the future. So these are the early thoughts, just to bear that in mind as we discuss these things today. So I'm just going to set the scene and give an overview of what the opinion is about. And you might be wondering, why have we had this rapidly called session to discuss the opinion of an Advocate General? And you know, really, it's obviously a super interesting field. You know, it encompasses lots of things, but this opinion and the to be released Court of Justice decision in due course is going to define a really complex relationship between rights holders, internet users, and service providers in the form of platforms. And you know, you could say there's actually a real philosophical divide in the views of how this area of the internet should be governed. And the outcome of this decision will really affect, you know, rights holders, service providers, and end users of the internet. So not just legally really interesting, but also practically, it's going to have real world effects on how users engage with the internet and with platforms. And I've just got a fire alarm going. So the setting the scene with the opinion. Why is there an opinion? Well, this is in the context of the Court of Justice proceedings. There's a reference from the Bundesgerichtshof in Germany for two cases. The first is in relation to a case involving YouTube, and in that case, the claimant, Mr. Peterson, claims copyright rights in certain Sarah Brightman recordings that were incorporated into videos, into images on the YouTube platform by YouTube users. And of course, if you know YouTube, you can then access those videos or stills, and they're available to the public. And Mr. Peterson said without his authorization. So he said, YouTube, take these videos down, and they did, but then they resurfaced. So he then commenced an action against YouTube. The second action, for which there's a reference, is in relation to the cyber locker called Uploaded, which is owned by Cyando. And Uploaded is basically a cyber locker that allows users to upload their content, upload their documents and data. And there's a certain functionality on it that allows users to share links to that file or to that data being stored on Uploaded. And in the context of this reference, a publisher had taken issue with the ability of some files that were medical journals. So nothing is quite as exciting as Sarah Brightman recordings, but these medical journals could be shared with other users of Uploaded, and the publisher said that was an infringement of their communication right. So the reference is all about you know, the scope of Article 3 and the communication to the public right, and whether that extends on to these types of platforms, as well as the Article 14 hosting defence. And in that case, where a platform may have information being stored on the platform at the request of its users, and in circumstances where, you know, the platform has no knowledge of that illegal activity, or where upon being given knowledge, it acts expeditiously to remove it. So that's obviously the hosting defence. So they're the two real main aspects of this case. So I'm just going to skim over the questions that were asked to the Court of Justice and give the answers in the Advocate General's opinion. As you all know, these are quite dense questions normally, so I have paraphrased them. So they're not exactly what have been referred, but it's my summary of them. So the first question: does a platform on which videos containing content protected by copyright made publicly accessible by users without the consent of right holders carry out an act of communication under Article 3 if the platform makes profits, if the platform uploads automatically and without control, if there's terms and conditions about copyright and that the platform obtains a license to use that globally, if there's tools by which right holders can take steps to block infringing videos, if the operator indexes and organizes that content, and if the operator is not specifically aware, or if they become aware of the illegal activities, they delete that content. Now, in the Advocate General's opinion, he said no, all of those acts being conducted, that does not mean the platform is communicating the works to the public. So that no infringement of Article 3. The second question being referred, and again paraphrasing, is does an internet video platform, under the conditions that I just described, come within the scope of the hosting defence? The Advocate General said yes, the hosting defence does apply to such platforms, even if they perform those activities that I just set out. The third question relates to the knowledge aspect of the hosting defence, and in that question is the actual knowledge of the illegal activity in order to lose the hosting defence. Does that relate to specific illegal activities? And the Advocate General said yes, the knowledge must be of specific acts. Simply having general knowledge or non-specific acts, that's not enough. And then finally, just for the summary purposes, the fourth question was all about in order to obtain an injunction under Article 8.3. So if you know, Article 8.3 is the InfoSoc equivalent of Article 11 of the E-commerce Directive, of the IP Enforcement Directive, and that's all about injunctions against non-infringing intermediaries. And the question there is, can you only get this type of injunction if a further infringement has taken place, again after notification of a clear infringement has been provided? And the Advocate General's opinion said, well, you should be able to apply for such injunctions without the need to wait for infringement to take place again, and without the need to show improper conduct by the intermediary. So that's a very, very quick overview of the questions being referred, which you need to know to understand today's discussion, and as well as the brief answer of the Advocate General. So let's sort of dive in and look at the detail of his opinion. And we're first going to start with Article 3 and the communication to the public right. And Eleonora, I know this is one of your specialties. So, what do you make of the Advocate General's reasoning that a service provider such as YouTube or Uploaded is not liable under Article 3?
Thank you, Jeremy, and hello, everyone. I would like to start by saying that also in light of the summary that you have provided, the opinion is premised on two key points. The first one is that these joint cases are about user creativity and platform liability, no? If you look at paragraphs 42 and 43 of the opinion, the Advocate General speaks about user-generated content, creativity of users online, participatory culture, etc. However, it seems to me from the background proceedings that in the national litigation, this is not really what is at stake, because neither in the YouTube nor in the Uploaded cases it is about user creativity, but it is about the making available of third-party protected content without any creative input whatsoever. So that is the first point, which I think is important also to appreciate the balance of different competing rights and interests. The second point is that if you look at how the Advocate General has titled Section 2 of the opinion, he writes, Article 3.1 does not govern the secondary liability of persons facilitating the carrying out of illegal acts. Again, if one looks at the preceding case law of the Court of Justice, this does not seem to be correct, at least in the understanding that the Court of Justice has so far had of Article 3. So I think that it would be more appropriate for the Advocate General to say that Article 3 is not that it does not, but rather it should not govern these types of things. So these are the two premises upon which the opinion is built. Having said that, I think that if you look at the opinion in general, it appears quite regressive. And I'm using this adjective in a neutral way. I'm speaking of regressive because the opinion invites to take a step back and perhaps review what the Court of Justice has done over the past few years with the communication to the public right, and invites overall a rethinking of the scope of this exclusive right. In this respect, I think that there are a few points that stand out regarding the construction of the right of communication to the public. The first one is that the Advocate General seems to acknowledge that yes, communication can be also about making available, but it is mostly an act that has to do with the transmission of a work. So it seems to encourage that the transmission approach is the one that should be favored. And if the Court of Justice was to adopt this reading, that would mean a major rereading of the entire case law on communication to the public. The second point is that instead, and as a reaction to that, he also has a rather broad reading of recital 27, which states that the mere provision of facilities is not an act of communication. He specifies that this recital should be read in the sense that mere provision of facilities does not mean a mere provision of mere facilities. So in this sense, if you have a platform that is as sophisticated as YouTube, it does not mean that the platform is a simple facility, which indeed YouTube and Google do provide. So this is an interesting reading of the communication to the public right as well. Then another important point concerns the notion of indispensable or essential intervention. We know that in the case law that has been issued over the past few years, the Court of Justice has progressively relaxed what qualifies as indispensable intervention. According to the Advocate General, the interpretation is not correct, and the approach should be not on whether someone has facilitated a third-party infringement, but who plays the most fundamental intervention. In this case, he thinks it is the users who upload content and not the platform, which allows this content to be displayed. And then another important point, which I think is, has come a bit as a surprise to those who have read the opinion, is the fact that the Advocate General seems to consider decisions such as GS Media, FinSpeller, and the Pirate Bay one as sui generis decisions, which were issued like that because it was a piracy-focused context, but they should not have any bearing beyond these very particular scenarios. I think that this is a major point, and I'm not sure that the Court of Justice would agree with that, but if it did, that would mean a significant rebalancing and rethinking of the communication to the public right. And then the final point which stands out is indeed the relationship between primary and secondary liability, because it seems that for quite a long time the Court of Justice has absorbed secondary liability into primary liability. So this is something that has happened, and I don't think that the Advocate General's characterization that this is not the case is correct. It is something that has happened, and then we can have a discussion whether indeed this is a correct approach on the side of the court, or whether it is an undue stepping on the foot of EU legislator. In addition to all that, I think that another point that is relevant to communication to the public is the reading that the Advocate General has of the DSM directive, which he characterizes as new law, something that applies in certain scenarios, but it is not a clarification at all of what Article 3 of the InfoSoc directive already states. So overall, it is a regressive opinion in the sense that it invites the Court of Justice to reconsider all its body of case law on Article 3 of the InfoSoc directive, at least since the 2006 Rafael Hotel's decision. So we know that there is not a system of binding precedent in the case law of the Court of Justice, but if the court was to agree with the Advocate General, then over 20 decisions would likely be erased from the books of the court, and probably also the copyright books dealing with communication to the public.
Just picking up that comment, I mean, what's the chances of that happening? Because I mean, I think we all raised our eyebrows with for example, with many of those cases, but GS Media and the importing of knowledge into this communication to the public, right? I think he said he has reservations about those judgments. So he's suggesting go back and reconsider them, please, Court of Justice. What are the prospects of that, do you think?
But I think that the GS Media is an excellent example, because the Advocate General in that case, Advocate General Watelet, had attempted to indeed have the Court of Justice change the course that it had taken with Svensson, no? And insisted, look, an act of hyperlinking is not an act of communication to the public. The approach that you have taken is completely wrong and it should be reversed. The Court of Justice did not agree, and tried to save the day by adding these additional criteria, such as knowledge, the relevance of profit-making intention, etc., to try and create an articulated framework for liability. If I had to place my bet, of course, you know, this opinion is interesting. It is probably worth mentioning that the Advocate General adopts a similar view to the one that he had taken in the earlier opinion in Constantine Film and YouTube, which was decided a few days ago. And both in this opinion and in that opinion, he spoke very clearly about the need to refuse a dynamic interpretation of the law. We know that dynamic interpretation is an approach that inter alia has been favored by Advocate General Spooner in his opinion. According to Advocate General of YouTube, this approach is incorrect, and the result is the one that we've seen both in Constantine Film and here. If the judge rapporteur in this case is the same that drafted the decisions in GS Media, Finspeller and Zigo, and that is Judge Marco Ilesic, then I guess that you know, it will be interesting to see whether he will go against his own case law.
Thanks. One other thought I had as I read the opinion, I was quite curious about the Advocate General's references to trademark cases in the context of Article 3, in particular citing Google France and L'Oreal and eBay, all in the construct of Article 3. It's one of the first times I think I've seen that for Article 3, but is this a new thing? Is there going to be more cross-pollination between copyright and trademarks, or did you have any thoughts on that?
But certainly we've seen a few decisions recently in which the relationship between trademarks and copyright has become more intense than what was the case in the past. But I agree with you that the reference to Google France appears very original in this sense. And the fact that the Advocate General draws from the refusal in that case of the Court of Justice to consider Google as making use of the trademarks is quite interesting. What it doesn't explore is the fact that the Court of Justice did not say that the referencing search engine did not make any use, but rather said that it didn't make any use in a trademark sense. So that is one point worth noting. The second one is that I wonder how helpful it is to have a trademark infringement analysis applied in the copyright context, since these rights are premised on different grounds, they serve different purposes, and the test of infringement is different. Another point that I think is worth noting is that in the opinion, trademark law is present also elsewhere. You might have noticed that at some point the Advocate General speaks about the reasonably circumspect internet user. that is a clear, trademark derived concept, and he uses that when he says that this reasonably circumspect internet user will never think that the content that he finds on uploaded comes from uploaded. So clearly there is no confusion, hence there is no infringement. It is an interesting line of reasoning, which I guess is a bit an unicum in the case law of the Court of Justice on copyright, if the court was to adopt this indeed approach.
Thanks, Eleonora. So the other interesting part of this judgment, or sorry, opinion, is Article 14 and the hosting defense. So we're just going to move into that now. And we know about from the Google case and from the L'Oreal case about the need for the platform with the service provider to be playing an active role in relation to this Article 14 defense. So Lowry, could you please expand more on this point and discuss what the Advocate General was saying in his opinion?
Yeah, sure. Thank you, Jeremy. Maybe first of all, just to note the obvious, which I still find interesting, is that the active role appears to be a central concept throughout the opinion, and not only when assessing eligibility for the Article 14 safe harbor, but also when assessing the liability for communication to the public, for under Article 3 of the Info Directive. So, for instance, the Advocate General notes some point that whereas he doesn't think that YouTube or uploaded can be held liable for communication to the public because they provide mere physical facilities, the line that they can't cross is that of active intervention. So, in a sense, active role. And I would argue that if you sort of follow this to logical sort of conclusion, what the AG has in his mind would be a kind of seamless system of copyright liability, whereby a service is either active, and that means that it goes beyond being an intermediary and is not eligible for the safe harbor, or it's passive and therefore provides mere physical facilities and doesn't, or is not eligible for safe harbors. And to me, that would sort of, it would seem to be kind of a pretty logical construction. But I would have to say in brackets that at some point it seems that the AG is actually contradicting this slightly when it says that if the court would, against his advice, actually hold that the services would be communicating to the public, the court would still need to assess whether they would be eligible for safe harbors, which in one sense seems to be a sort of application of quantum theory to copyright, in the sense that in some circumstances it seems that the Advocate General thinks that a service can be at the same time passive and active. But we can hold that thought. But so essentially where I believe that the Advocate General in this opinion makes the crucial error is when he interprets the scope of Article 14 of the E-Commerce Directive, and when he sets out his criteria for the active role. And I would say that actually reading the opinion, I think that sort of the fundamental reason underpinning this error is that he seems to regard the safe harbors more as a legislation that should protect the ISPs rather than a piece of legislation that should strike a fair balance between the need to protect rights, and in this case copyright, and the need to ensure that the internet services can develop. So there seems to be a sort of a policy bias in favor of the ISPs in this case. But regarding, first of all, the scope of Article 14, if you look at paragraphs, I think 144, 146, the AG seems to suggest that the Article 14 needs to be construed in a broad manner, and that it should cover all services that store content at the request of the user as part of the services that they offer, for as long as the service still can be regarded as an intermediary service provider, which means that they remain technical, automatic, and passive. And in my opinion, as a starting point, this is incorrect. And it's not in line, as far as I can see, in line with the sort of the plain textual reading of the Article 14 of the e-commerce directive, which is actually quite clear. It covers services that consist of storage of content. The directive does not refer to a service that includes the storage of content. And why is this important? I believe this is important because the AG's interpretation could extend the scope of the safe harbor privileges way beyond what the legislators 20 years ago seemed to have had in mind when they drafted the legislation. And there's an interesting parallel here. I'm sure that you have all read the US Copyright Office Section 512 report, which recently came out. And among other many points, it discusses this very similar point under the US law and makes a similar point in terms of what kind of services should to begin with be subject to the hosting service provider safe harbor in the US. But anyways, I digress. And I think what we can see is that sort of the expansion of the Article 14 safe harbor is precisely the result of the opinion, if it's followed. And that's a function of, first of all, the expansive interpretation of the sort of basic condition, and then the active role, and how the AG interprets the active role. And the test the AG seems to apply is one of intellectual control. So a service assumes an active role when it acquires what the AG calls intellectual control over the content. And under that test, to be disqualified from the safe harbor, a service would have to actively select the stored information or be actively involved in the content in some other way so that the content is presented as its own. And I would argue that this test pushes the threshold for what is still passive way beyond what the court, for instance, has applied in L'Oreal in particular. I'm sure that you will all recall that in L'Oreal, what the court held was that a hosting service provider no longer remains passive if it gains knowledge or control over the content. And it assumes it gains such control, for instance, by optimizing the presentation of the content or promoting specific offers. And the difference between the courts and the AG's test becomes very clear when you look at it, how the AG is then applying his test in sort of the practical arguments made by, in this case, by Peterson and Elsevier. And I think that probably the most striking example of the effects is when the AG looks at the recommendation, which is something like, for instance, a service like YouTube does. So what YouTube does, it recommends to its users the content that they may like. And the fact is that in those situations, the uploaders have no idea what content is being pushed and to whom. The only one that has knowledge and control over that is the platform. And yet the AG seems to think that that is not active enough. So it seems to me, just to finish off, that what the AG wants to do is to ensure that user upload content services are not liable under the EU law, which I don't think is in line with the intent or the text of Article 14 or the court's subsequent case law.
Just on that topic of control, and what about the situation where a service provider is actually proactively trying to take steps of remove illegal content on its own volition. What do you think, or what's the Advocate General thinking there about does that mean they're in control of the information if they're actually doing their best to try to stamp out or to remove illegal activity?
Well, I think the Advocate General is very clear on that point, and he believes that should not be regarded as assuming control over the content. And on that point, I would probably say personally that on that point I would agree with the Advocate General that that's not what control in these circumstances would and should mean.
So the Advocate General is trying not to penalise a platform by doing their best efforts, basically,
or trying to. I mean, look, I think the Advocate General is saying, which is sort of common sense, you shouldn't penalise someone that is, using its best efforts to make the right thing. I think most people would agree with that.
Yeah. And still on control, what about the structuring and indexing of the content? Because I know in previous cases that may give rise to liability if they're sort of organising or indexing the content. I think the Advocate General was discussing this as well in the context of control. What did he say about that?
Well, again, the Advocate General thinks that is not enough. But then that's where it gets interesting, because as I said, it would seem that the Advocate General is almost foreseeing an environment whereby the Article 14 eligibility and what is communication to the public should be decided based on the same criteria. And if that is the case, then arguably you're looking at, for instance, Pirate Bay and the rest. The court believes that is enough for a service to actively intervene in the communication to the public and be liable for the communication to the public. And I would argue that similarly that crosses the, if you will, the line, and it does make a service that is indexing and or organizing the content liable for the communication to the public and also not eligible for the safe harbors. You intervene with the contents in a manner which makes you, if you will, no longer passive.
Yeah, thanks, Larry. That's really interesting. Just still on Article 14, I'm just going to move into the other part of Article 14, and that's about knowledge in the context of the hosting defence. And I think there was, as I mentioned at the beginning, there was a question about the type of knowledge where a service provider might lose the hosting defence. So, Julia, could you just explain what the Advocate General's thoughts on this particular topic were?
Sure. I think it's very interesting to point out on two levels, so to speak, what is meant by actual knowledge according to the Advocate General. The one is the question regarding kind of general knowledge, where the AG is quite clear in saying that there has to be awareness of a specific illegal activity or specific infringement. So it is not enough to be generally aware that infringement is happening on a platform. However, there again, there is a very interesting exception from that rule. That is to say, if the platform actively supports infringement happening by way of the design of the platform, then there is still liability. So while I agree with Eleonora that the Advocate General diverts from the interpretation of communication to the public in the Pirate Bay case, he still comes to the same conclusion in the end by saying that the Pirate Bay would have still been liable, but not because of the way that it structured and indexed the content, but because it actively supported infringement. So general knowledge is not enough to generate liability, but actively supporting infringement it would create liability. The second question then is, what does actual knowledge mean in terms of the specific content? Does it mean knowledge that the content exists on the platform, or does it mean knowledge that the content is illegal? And this is a very important distinction in the context of copyright, because unlike other types of illegal information, the copyrighted material is not illegal in and of itself, but because of the content, the context in which it is used. And there, the Advocate General is quite clear in saying that it's not enough to constitute actual knowledge that the platform knows that the content is there, but it also has to know that the content is infringing. So this means that the Advocate General is creating some very interesting criteria for what should be in the notice. And this is very interesting for the discussions that we are having on the Digital Services Act at the European level at the moment, because so far there is no harmonized notice and takedown regime. Article 14, it just creates an exemption from liability, but it does not create a positive obligation to create liability. So the whole question of the notice and action regime is not harmonized at the moment. And so when it comes to copyright, the Advocate General says that in order for the platform to be able to know that something is infringing, it needs to know that we are talking about a work, because not all material is protected by copyright in the first place. We have to know who is the right holder and whether the person who uploaded the content had a license to do so. And then finally, whether an exception or limitation applies. And in some cases, the Advocate General points out this is relatively obvious. If there is, for example, a whole feature film uploaded to a platform by some new user, it's quite obviously infringing. But if there could be an exception applying in this case, then the right holder should include information in the notice about why they think that this use is infringing. So this is quite interesting, and I think it also relates in an interesting manner to the case law on general monitoring, because I think unlike the question of communication to the public, when it comes to general monitoring, the AG's opinion is not, as Eleonora put it, regressive at all. It's not contradicting anything the court has previously said on general monitoring, but it is actually reconciling it. And this was quite difficult up to this point, because we have, on the one hand, the copyright-related case law on general monitoring, especially the Sabam cases and McFadden, that said that in general, kind of upload filters would constitute a general monitoring obligation. And then we had the defamation case in Facebook, where the court said that it would not constitute general monitoring to have a stay down requirement for a specific illegal act, in this case, a defamation. And here the Advocate General actually manages to reconcile those two at first seemingly contradictory provisions by saying that it is specific monitoring if a platform has to ensure stay down of a specific illegal activity. And in the context of copyright, this does not mean a specific work, but rather a specific infringement. So this means that a court can issue an injunction for stay down without this constituting a general monitoring requirement if the stay down does not refer to all uses of the work, but rather a specific use of the work that is considered infringing. And personally, I still find it's somewhat problematic to consider any stay down obligation compliant with the ban on general monitoring, but at least this is kind of a means of reconciling the case law in Sabam and McFadden on the one hand, and Facebook on the other hand, to say stay down is a specific monitoring if it relates to a specific infringement, but it would be general monitoring if it requires the stay down of all uses of a particular work without a court checking first whether those uses are actually infringing or covered by an exception or limitation. So that, I think, is, well, not at all overruling any of the previous cases, but rather bringing them together.
That stay down point is actually really obviously topical for lots of reasons. Just a thought on that. If given this interpretation is not just applicable to copyright, it's Article 14, which is applicable to all sorts of rights. So what is the Advocate General thinking in terms of let's say a trademark protected product, if one user is say selling an infringing or counterfeit product, and that product is taken down, and then if there's other different users or sellers or whatever selling the same counterfeit product, do you think, is the Advocate General saying they should be taken down as well? Are they specific? Is that specific knowledge or is that general knowledge?
Well, the Advocate General doesn't explicitly say that, but if you look at what the court said in the Facebook ruling, the decisive criterion is whether or not it is possible for the platform to make this assessment automatically without any assessment of the specific case. So this is far from trivial in the Facebook case alone, because it's not very obvious in which cases it is possible for a technological system to see whether something is an equivalent statement or not. But I would say it would depend on that, whether a lawyer or a person would have to look at it and make an assessment. In that case, it would be general monitoring, or whether it's literally just a question of looking at an identical file. So I think that would be the distinction.
Yeah. Okay. And just finally on this area, from a platform perspective, in light of what the Advocate General's recommending, what do platforms, what are their sort of, what should they be doing if they receive a notice and takedown notice in relation to some products? What's the Advocate General saying are the obligations on those platforms from a practical perspective?
Well, I think the Advocate General is not changing what a platform should do with a notice. I think it's rather a clarification of what the notice should contain. So I think if the notice contains all the information that is necessary for the content to be obviously infringing to the platform, then the platform still has to delete the content. But I think it's very interesting in the context of what we are currently seeing with the Digital Services Act, that indeed it would not be possible probably to have kind of a fixed deadline for the deletion in the way that it is being discussed, for example, in the terrorism regulation, because the Advocate General says it is a case-by-case assessment what is considered expeditious. So it depends on what information is actually provided. So that would indicate to me that it would not be possible to create a fixed deadline in this harmonized notice and takedown procedure. It would still have to be something like expeditiously, because exactly how obvious it is that something is illegal content would depend on the specifics of the case and on the specifics of the notice.
Thanks, Julia. So just moving to the fourth question, which is the conditions which are considered for the grant of against a non-infringing intermediary, an injunction against them under Article 8.3. Larry, could you please explain the issues here?
Well, I think I can be very, very brief. As far as I understand it correctly, the background to this is 8.3, which obliges member states to grant to make it possible for right owners to apply for, if you will, no fault injunctions against intermediaries whose services have been used to infringe rights. And this particular provision has not been implemented in Germany. And that is on the grounds, if I understand correctly, that the German government considers that the Störer liability already provides for injunctions against including intermediaries. The thing is, though, that under the Störer liability, you still need to find a breach of a duty of care and obligation. And what the Advocate General is saying is that is actually not in line with the EU law, in the sense that 8.3 is essentially, is exactly what it says on the tin, i.e. it should be available without finding the need to find any kind of breach of duty or right, so no fault. That, I think, in essence is the sort of background of that question, and also the AG's conclusion.
Okay, thanks. Just a few thoughts for the panel to discuss, really. I think an important part over the last decade in all the decisions has been an attempt to strike a balance between the competing interests of right holders and of service providers, and that's always the language that is used. So in your opinion, do you think the Advocate General is striking the right balance here? And I'd love your views on that. Eleonora, maybe if you could give your thoughts first.
Yes, thank you, Jeremy. Of course, the issue of a fair balance has been becoming increasingly important and topical over the past few years. And of course, it is apparent that when it comes to an online context in which on the one hand there are right holders, on the other platforms, on the other users, striking the right balance often proves challenging. Having said that, certainly if the court were to endorse the Advocate General's interpretation, then the only types of platforms that would be considered liable for the hosting and making available infringing content are those which are piracy focused or present the content as their own. This way, I think that there will be a restriction in the scope of communication to the public, and as it was explained before, also I think it is appropriate to consider that also the scope of safe harbors will be broadened in response to all this. Having said that, as I mentioned in my intervention, the Advocate General refers to different competing rights, which correspond to a variety of different fundamental rights. He refers at some length to freedom of the arts, for instance, in Article 13 of the EU Charter of Fundamental Rights. But as I mentioned, if you look at the background proceedings, here we are not really dealing with cases of user creativity, but blatant infringements of third-party rights. Having said that, I found quite interesting the take of the Advocate General regarding the protection that still remains available to right holders if the court was to endorse his take. And he refers to the fact that it is still possible for right holders to take action directly against the infringers' uploaders, and in this respect they can request platforms to disclose, for instance, names and addresses. Those who are listening and are familiar with the Constantine film decision will promptly recall that a few days ago the Court of Justice said that these addresses do not include IP or email addresses per se, at least on a EU level, and these are the only things that actually would be useful to obtain because indeed no one provides YouTube with their postal address. Then he refers to the possibility of sending a notice and takedown, possibility to request an injunction, and the fact that in the context of Uploaded or YouTube, since these are centralized platforms, it is not a problem to do all these things because it is not a situation like the Pirate Bay in which you have to deal with different torrent sites, etc. So he finds that this system is sensible and can be easily implemented. I don't know whether that translates to truth in practice, but certainly the types of balance that he envisage is different from the one that the Court of Justice has considered to be appropriate so far. So let's see if these signals a change and shift in the approach to online copyright protection.
Thank you. Lowry, how about your thoughts on this?
Well, I may already have sort of my thoughts, but all that to say, no, I don't think this this manages to strike a fair balance. I think this shifts the needle quite a bit in favor of the ISPs, the platforms, and actually sort of to Eleonora's point about this is a regressive decision or opinion. And I would pick another point, which is, I found it frankly quite shocking that the Advocate General is saying that, but all is fine because right owners can still sue the individual uploaders. Just to remind everyone, that has been tried some years ago, and I don't think the results were necessarily something that people would endorse. So instead, the Advocate General seems to be saying that fine, sue the uploaders, but leave the platforms that are aggregating the content and making money of the content alone. I don't think that's a right policy, and definitely not striking the fair balance.
Thank you, Lauri. Julia?
Well, you will not be surprised that I have a slightly different view on this. I think the Advocate General strikes a very fair balance, and I don't think that he is fundamentally changing the direction of the court's previous decisions in copyright cases. Because if you look at GS Media was not about an intermediary. In this case, it was about a website posting the links themselves. So the whole question of the interpretation of the e-commerce directive did not really apply there. And then Filmspieler and the Pirate Bay were both cases where the AG says those platforms did support infringement, so they should have been liable. If you look at the eBay case, I don't think it is fair to say that the legislator in the introduction of the e-commerce directive did not want to strike a balance that also ensures that platforms can continue to exist. I mean, eBay was founded in 1997, so I think it's very reasonable to think that in the 2000 e-commerce directive, the legislator did have those kinds of platforms in mind. And I think it struck a fair balance in the sense that it said in the specifics of the L'Oreal case, eBay played an active role and therefore was liable. But that doesn't mean that eBay is an active platform. There is no such thing as an active platform. If eBay was an active platform and could never benefit from the safe harbor, this would basically mean that eBay would be liable for every single copyright infringing image that a user uses to illustrate the product that they're selling without having any knowledge that this picture is infringing. I think that would be an unreasonable interpretation and extension of the eBay ruling, and so does the AG. So I do think that overall, the right holders would receive a sufficient level of protection, because I'm a little bit startled by the way that the possibility of a no-fault injunction is being downplayed. I think comparing to the current situation under German law, a no-fault injunction would be quite a significant increase of the possibilities of right holders to go against infringement on platforms. And then at the end of the day, the Advocate General also says that the whole question of licensing is at the end of the day an issue for the legislator to address. And well, Article 17 has been passed, and there is certainly a question about whether it complies with the ban on general monitoring and the protection of fundamental rights, but there are also provisions on licensing. I think that will have to be implemented, and that might shift the balance in favor of rights holders. But I don't think it would be fair to say that users' fundamental rights to freedom of expression, freedom of information, freedom of the arts should not be considered in the assessment of whether a platform like YouTube communicates to the public, just because the specific case that was referred to the court is a case of a blatant infringement. Because we quite often have these situations where the cases that we have before the court do not involve the users. The cases only involve the right holders on the one side and the platform on the other side, and nobody is advocating on behalf of the users. So I find it quite positive that the Advocate General is nevertheless taking the impact of this decision on users' fundamental rights into account if it doesn't get applied just to this particular case, but any case of expression on a platform like YouTube. So in that respect, I think it does very much strike a fair balance, perhaps more so than cases that only look at the positions of right holders in platforms, but not of users.
Thanks, Julia. I told the audience there was a philosophical divide on this, and there we go, right on this panel as well, which makes it really, really interesting. So just to wrap up, I've got a so what question. So what about the opinion? It's an Advocate General opinion. The Court of Justice has a long precedent of not following Advocate General opinions, like in GS Media, as Eleonora already mentioned. What's the prospects of this being followed? Any thoughts there?
Personally, I can say that I conducted a study into the relationship between Advocate General opinion and resulting court decisions, and statistically it seems more likely than not that the court follows an AG opinion if the AG adopts an expansive reading of copyright norms. So this is what has happened in the past. We don't know whether it will happen in the future, but it is, I hint into what might be the thought process of the Court of Justice. And then there is, of course, the key issue that it is not that here the relationship is between one single case and these pending cases, but it is about years of progressively construing the right of communication to the public in a certain way. So it will take, I would say, a major rethinking on the side of the court. I repeat that because I think that the opinion of the Advocate General signals a change of approach in communication to the public. And if the court wishes to follow that, then that would mean that there is a change of direction. Legally, of course, that is possible since there is no system of binding precedent in the CJU court system. But as a matter of fact, there is, somewhat of a substantial informal precedent, at least since the Da Costa decision. And in fact, often we see the Court of Justice referring to earlier cases as a settled case law, and rarely there is, a departure from positions previously taken. Also considering that here, the judge rapporteur, if I'm not mistaken, is the same one who has drafted the decisions that the Advocate General so much criticizes. So let's see what happens. But I think these are all factors that might be taken into account when casting any bet.
And finally, one of the things I also saw in the opinion was a paragraph about and reference to the new regime under the new copyright directive under Article 17 in particular. So given that new regime, what's going to be the significance of the outcome of this opinion, bearing in mind the future under the new directive? Laura, do you have any thoughts on that?
Yeah, I mean, look, absolutely right. There are now new rules in Article 17, and obviously, the AG believes that this is now a new liability regime. I personally would respectfully disagree. I mean, basically on the grounds that we've discussed, which is this is rather the Article 17 is rather a codification of the existing court's case law and interpretation. And there's an interesting detail there, by the way, in that the Commission's original proposal actually included this clarification in a recital, which would strongly suggest that this indeed is a case of mere clarification. But whichever way, there are new rules. But the point is that those rules obviously apply only a certain set of internet platforms. Should the Advocate opinion be followed, I think it would have then negative effects, if you will, outside the scope of Article 17 in terms of interpretation of communication to the public, as well as Article 14.
I would love to come in on that.
You do.
Yeah, first of all, I think it's pretty obvious that Article 17 is not just a clarification of the concept of communication to the public. I mean, if this were the case, you could end up in a completely counterintuitive situation where a platform could fail to meet the definition of an online content sharing service provider under Article 17, but still be considered liable because it performs an act of communication to the public, because the definitions are not the same. So this would mean, I mean, the legislature tried with the definition of online content sharing service providers to target a specific type of platform. And that would then mean that you could have a situation where a platform that has been less active, if you want to use that wording, that would not benefit from the liability exclusion mechanism of Article 17. That would be completely, I think, counterintuitive. And since you mentioned that the Commission used the word clarify in a recital, well, the Commission itself argued in this case that obviously Article 17 goes beyond the notion of communication to the public in Article 3. So if you want to use that standard, I think the Commission was very, very clear in this court case, as the AG cites it, that Article 17 is not just a clarification.
Go figure.
On that, I think that in relation to your last point, an interesting element to notice is the following, that the European Commission that pleads before the Court of Justice is not the same European Commission that proposes legislation, because the former is the legal service of the Commission, and the latter is the copyright unit. So I think that this part of the opinion and this part of the Commission's observations should not be read as the Commission saying, look, what we said in the past is not what is true, and we were wrong to say something like that, just because, you know, they are different subjects. So this is something that I think it might be worth noting. Another thing is that if the Court of Justice were to follow the Advocate General, in principle, you know, YouTube will fall under the definition of online content sharing service providers, but uploaded will not, because cyber blockers are excluded from the definition of online content sharing service providers. So also the final part of the opinion that, look, there is this new regime, so that is for the future. We are all, you know, looking forward to seeing what happens there, is not necessarily said that this Article 17 would apply to the situations that are at stake in this particular case.
That is true, but I don't think that's necessarily a problem. I mean, first of all, it doesn't, I think, go without saying that whatever the result must be, that the right holders win the case. But I think the Advocate General even distinguishes between YouTube and Cyando in an interesting way. I mean, I think it's true, if the court follows the AG's interpretation of communication to the public, it would come to the conclusion that neither of them communicates to the public. But the Advocate General also acknowledges that it's possible that the court wants to continue to along the path of GS Media and the Pirate Bay. And in that case, he actually says that the criterion should be whether or not the platform plays a central role. And there he is a bit more uncertain when it comes to Cyando than when it comes to YouTube. So he says YouTube does not play a central role, but Cyando might, because of the special partnership program that Cyando offers. So it could also be that the court follows the opinion for the most part, perhaps not on communication to the public, and then there would be a different decision on Cyando than there would be on YouTube. But I think finally, on the question, what is the significance of the AG opinion for the interpretation of Article 17? I think it's the general monitoring obligation, because Article 17 clearly says that the application of the article must not lead to a general monitoring obligation. So that would mean that what YouTube is doing with Content ID at the moment would not be okay, because YouTube is currently completely ignoring the application of copyright exceptions and is simply deleting identical works rather than identical infringements. And that would probably not meet the fundamental rights requirement that the AG has construed. And even if Article 17 didn't say that there shall be no general monitoring requirement, he also says that the general monitoring requirement is founded in the fundamental rights and applies regardless of what the directive says on that.
Although sort of Article 15, if I recall correctly, only applies to services that are covered by the safe harbors, not to any kind of service, in particular those that are liable. So
that's exactly what he contradicts.
That point doesn't quite hold, doesn't quite stick. But
it says on Article 17 itself that there shall be no general monitoring obligation.
I think it refers to Article 15 as well. So
no, but it says in Article 17, paragraph 8, that the Article 17 shall not lead to.
I'm happy to disagree with you on this one.
Well, let's not disagree on the facts. We can disagree on opinions.
Exactly. Opinions, we can have different opinions, but facts are facts. I fully agree with you on that one. The other point is actually, which is something to sort of to keep in mind, is the exclusion of certain type of services, if you will, from Article 17. And I would actually disagree on, Eleonora, what you said, that you uploaded would not be covered by Article 17, because if I recall correctly, the services that are referred to are local services for private use, and arguably a service like uploaded is not for private use because it allows widespread sharing and even induces sharing. So I think, it's not that clear cut, and I would rather argue that actually uploaded most likely would be covered by Article 17.
Excellent stuff. Thank you all for those comments. It just shows what a fascinating area this is. So it's 4:13 in the UK. Maybe we could have time for a couple of questions. There's been a lot of questions coming through, and I've filtered them out as we've been speaking. There's been a number of questions about the intersection with the Article 17 regime. I think we've covered that, so apologies for those people. I don't think we need to go over those again. Here's one question from Deidre Kilroy, and it seems Xavier Cahorn has also asked the same or similar question, so it's great. Where a platform provider attaches metadata for ease of search, is this going to trigger a difference in treatment? Also, what about where, because of server structures, mirror copies of the locker are created / restructured? Has anyone got some views on that? Presumably for control.
I guess according to the logic of the Advocate General, it would not trigger a different treatment because it doesn't relate to the content. That would be my initial reaction.
Yeah, you might well be right under the Advocate General's view. However, I think I would say that a more traditional view is that if the platform actively actually attaches metadata, so if you will marries the content and the metadata, then arguably that's shows that you do actively intervene in the communication, and also arguably you have actual knowledge of what is being made available.
Should I just ask one more question? So this is long. Aside from the context of stay downs, do you believe that according to the criteria from the opinion, a right holder could simply state in the notice that all instances of uploading a given work are infringing, without identifying specific instances and or users who uploaded them. I'm trying to wrap my head around the requirement to describe the alleged infringement. Does it have to refer to each upload individually? Also, thanks for the inspiring discussion. Bodan Widler.
Well, I don't think it has to refer to every specific upload, but it does have to refer to every specific infringement. So you can't simply say, please delete all the instances of this work, because they might actually be legal under a copyright exception, for example. But the Advocate General makes this distinction between the same file and the same infringement. So there can be different files that still constitute the same infringement. So if a picture, for example, is uploaded as a JPEG instead of a PNG, that would not constitute a different use, but rather a different use is if you are using the same work in a different context, and that could therefore constitute a legal use, for example, under a copyright exception.
Great. I think that's probably all we have time for, really. Given the time, it's now past 4:15. So apologies if I haven't been able to read out your questions. Thank you for asking the questions. I think as you've probably realised, it was a very full discussion. So hopefully, you've learned a lot from our experienced panelists. So I'd like to say thank you to the panel for this really, really inspiring discussion on the, I suppose you could say, the interim stage of this preliminary reference. And obviously, we look forward with great interest to see how the Court of Justice decides the matter. So thank you all, and thank you to the audience for attending today. It's great to have so many interested people watching this discussion.
And thank you from BLACA and IPKat to Jeremy for sharing it so brilliantly. Thanks.
And of course, thank you to Lauri and Julia for agreeing to participate in today's discussion. Very much appreciated. Thank you to both.
Alice and I will give you a round of applause. We're the only ones who can clap. The audience is silent.
And thanks to all those who have registered and attended today's webinar. Thank you.
Fantastic.